Welcome to the deep dive. Sometimes the absolute core of a complex legal battle, the real story, it isn't buried deep in the formal court filings, the complaints, or the
No,
motions.
not at all. Often it's kind of hidden right out in the open.
Exactly. Within the raw evidence, those everyday emails and text messages, the sometimes brutally honest ones exchanged between the key players,
hmm Caught right in the middle of it all.
these communications are often, well, unvarnished, aren't they? Captured right in the moment.
Yeah, they're not polished legal arguments. They're often just off-the-cuff remarks or notes on, like, operational hitches or strategic chats happening in real time.
And when those get pulled into discovery, filed as court exhibits.
Then you get this unique, unfiltered glimpse into what was really going on behind the scenes.
And that, right there, that's the heart of our deep dive today. This exploration was actually specifically requested by you.
That's right. You asked us to focus on extracting the most impactful insights from, well, this stack of source material related to a pretty significant legal case.
In the payment processing industry, no less.
Yeah, the case we're zoning in on is CardConnect, LLC v. Shift4 Payments, LLC. The source is placed in the U.S. District Court for the Eastern District of Pennsylvania.
And we've got the case numbers here from the source, 2.19CV01304-MAK and 2.19CV01333-MAK.
Based only on the material you shared with us,
Yeah.
the core of this whole dispute, well, as alleged, it revolves around claims of breaches of contract, accusations of tortious interference.
And critically, assertions of misappropriation of trade secrets.
Exactly. And it all centers around payment processing services, which, is just critical infrastructure for so many businesses today.
Absolutely. So what are we working with here? What's our source material look like?
Well, we've got excerpts that are directly related to the court filings. Things like descriptions of docket entries, lists of exhibits, and crucially, transcriptions or maybe theoretical outputs of specific exhibits. And the focus, like you asked for, is on the specific emails and text messages, right there in the exhibits.
Got it. So our mission for this deep dive is pretty clear then.
Yeah.
We are going to go through these very specific pieces of evidence, these messages, these emails pulled directly from the sources you gave us.
Right. To try and understand the pivotal moments, the core arguments.
And the underlying tensions, too, of this really substantial legal dispute.
All revealed through the direct, often pretty candid communications of the people involved.
And we need to stress this. We are strictly sticking to only this provided material to build our understanding.
Absolutely. No outside info.
It's about seeing this serious legal case through the very specific, sometimes, well, uncomfortable lens of these raw exhibits.
Okay, so where do we start? Maybe lay out the fundamental battle lines first.
Good idea. The overall legal claims and the core disagreements, just based on what the sources tell us.
Right. So from CardConnect's perspective, based on what we see in the material, their position is that Shift4 was essentially trying to walk away from its obligations under their agreement.
Just trying to bail.
Well, and maybe more than that. CardConnect also alleged that Shift4 went further. They claim Shift4 built a competing product, like a gateway technology, using CardConnect's proprietary information.
Okay, now that gets right to the heart of that trade secrets claim you mentioned.
Exactly. And there's this really fascinating detail in the source that CardConnect apparently used to support that claim.
Oh, yeah. What's that?
CardConnect alleged that Shift4 actually asked to purchase CardConnect's intellectual property at one point. And CardConnect's argument, which, sounds pretty logical based on the source,
Right.
was that you wouldn't need to purchase something if you already legitimately owned it or, had the right to use it.
That makes perfect sense. If they were using your proprietary info improperly, then them later asking to buy it, yeah, that would look pretty damning. It undermines any claim they had prior rights.
Precisely. The sources also detail CardConnect's argument that Shift4's notice of termination when they tried to end the agreement was untimely.
Untimely how?
They contended Shift4 couldn't just give notice to terminate for convenience, like whenever they wanted during the contract term.
Okay.
And CardConnect specifically alleged that Shift4's real motive for terminating, well, it was because, and this is supposedly Shift4's own words, according to CardConnect's allegations in the source.
What did they allegedly say?
We are the losers on the deal because bidding on the active accounts was just too expensive.
Wow. Okay, let's pause there. CardConnect alleging Shift4 said, "We are the losers on the deal because it was too expensive."
That's a really powerful claim about motive, isn't it?
It absolutely is. It paints this picture of Shift4 just trying to ditch an unprofitable situation.
which CardConnect argues wasn't a valid reason for termination under their specific agreement.
Exactly right. And the source reveals the scale of what CardConnect was actually going after here.
Meaning,
CardConnect's CEO, according to the material we have, wasn't just focused on recovering, say, lost payments. No, they were seeking long-term protection.
long-term protection. Okay, that sounds like more than just money. It suggests they were looking for a much more fundamental resolution. They even discussed the possibility, get this, that a judge might order Shift4 to sell the technology back to them as a specific remedy.
Whoa. A forced sale of technology.
Yeah.
Technology built using allegedly misappropriated info. That's a serious remedy to pursue.
You're telling me. And the potential financial scale. Just huge.
The source mentions this.
Yeah, it notes CardConnect's CEO discussing an estimated value potentially in the, wait for it, $200 to $300 million range, depending on the number of merchants.
$200 to $300 million.
Enormous stakes. And the source also adds that Shift4's view, well, as presented in the material, was that this estimation sounded a bit optimistic.
Ah, I bet they did. But that back and forth on the value, even that little detail, it just underscores how much was really on the line here.
Absolutely. This wasn't some minor disagreement. We're talking potentially hundreds of millions of dollars.
Okay, so that's CardConnect's side, as laid out in the sources. Shift4 naturally had their own counter-arguments, also detailed in the material, right?
Oh, absolutely. They disputed CardConnect's interpretation of the contract. Shift4 argued they did have the right to terminate.
But not just whenever.
Well, importantly, they contended the termination wasn't for convenience. That's the key distinction they were making.
Okay, so if not for convenience, then why?
They framed it more as a response to CardConnect's alleged breaches, and also tied it to other strategic business decisions, like the potential data cap acquisition mentioned in the sources.
Ah, data cap. Let's talk about that. What was Shift4's position there?
The source material highlights Shift4, arguing that a term sheet they had concerning that data cap acquisition, well, it had too many open material terms.
Meaning
it could be considered a binding agreement. That was their stance.
And the implication of that is?
Therefore, in their view, just entering into that term sheet didn't trigger any exclusivity clauses they might have had with CardConnect.
Okay, I see. So if the data cap term sheet wasn't legally binding,
then pursuing it didn't violate their agreement with CardConnect. That was Shift4's argument. And they believe their legal position on what constitutes a binding agreement and, its implications, they felt it was supported by precedent.
the source mentions specific courts.
Yeah, specifically Delaware courts.
Okay, so this whole legal interpretation of whether a document is binding versus non-binding, that seems pretty central to Shift4's defense, especially against that tortious interference claim.
Exactly. If the data cap document wasn't binding, Shift4's argument is basically, hey, we didn't violate any exclusivity with CardConnect.
Makes sense. But Shift4's justification for termination wasn't just about costs or this separate deal, right? You mentioned alleged breaches by CardConnect?
Correct. They also pointed the finger back at CardConnect.
How so?
The source specifically mentions that on October 26, 2017, Shift4 sent CardConnect a formal notice via certified mail, detailing what Shift4 considered to be material breaches by CardConnect.
And what were those alleged breaches?
The ones listed in the source include CardConnect adding merchants who've been previously terminated, specifically merchants placed on the terminated merchant file, or TMF.
Right, the TMF. That's basically the blacklist for merchants, isn't it? High risk, problematic.
Pretty much. Onboarding merchants from that list is a huge compliance issue in the payments world. It's a big red flag.
What else did Shift4 allege?
They also claimed CardConnect was disregarding card brand rules, rules set by Visa, MasterCard, Amex, etc., specifically with its advertising, how they were marketing payment services.
Okay, so Shift4 sends this formal notice. What happened then?
Well, according to the source, Shift4 alleged that CardConnect basically just ignored this formal notice of material breaches.
Ignored it.
And continued these alleged violations. So this helps frame Shift4's later actions, including the termination.
Ah, I see. Not just as them trying to escape an unprofitable deal.
Right. But as a potentially justified response to CardConnect's own alleged failures and noncompliance. That's the narrative Shift4 presented based on our sources.
Okay, so we have these really competing narratives taking shape. CardConnect saying Shift4 breached by using proprietary info, building competing tech, trying to buy IP they didn't own, and ultimately trying to ditch the agreement when it got expensive, claiming Shift4 literally said, we are the losers. And then Shift4 countering saying, no, you breached first, TMF merchants, advertising rules, plus our termination was justified based on those breaches and our interpretation of the contract terms, especially regarding that data cap deal.
And that whole dispute over whether the data cap term sheet was truly binding seems like a critical legal linchpin in their argument, as presented in the source material.
Absolutely. Okay, now that we've kind of set the legal stage, the battle lines based on the sources, let's dive into the specific communications, the exhibits.
Yes. This is where things often get really interesting. You see the details, the human element, maybe even the potential smoking guns.
Let's start with the early interactions. Around 2016, 2017, you said they paint a picture of enthusiasm, right? Partnership.
Yeah, it's quite a contrast to where things ended up. If we look at Exhibit 39, that's part of docket entry 26440, there's an email from Jay Isaacman to Jeffrey Shanahan, dated August 26, 2016.
And the tone.
Genuinely eager, almost excited about working together. Isaacman writes, pretty straightforwardly, just let me know when and where to sign stuff.
Ready to go.
Totally. And he lays out a clear plan. Integrate a hosted solution to the CardConnect gateway.
Okay.
And the explicit strategic goal, to eliminate a pretty big dependency on first data.
Whoa. Okay, so this wasn't just some minor tech hookup. This was aimed at shifting a core business dependency away from first data, CardConnect's parent.
Seems that way. And the benefit was framed as mutual, too. The email explicitly states, so this is kind of a big deal for Shift4 and good for CardConnect as it will equate to a lot of quality volume.
Quality volume. That's the language of a symbiotic business relationship right there.
Exactly. It wasn't positioned as competitive at this stage. It was framed as a partnership that would bring good business to CardConnect.
And the closing line.
The excitement's palpable. Can't wait to get started. So this email, filed as an exhibit, it really captures the optimistic start of this relationship, before it all went south.
Okay, moving forward a bit. September 2017. What do the communications show then?
Well, we see Shift4 clearly innovating, building new tech, and actually pitching it. There's an email from J.D. Oder II to Mike Summers and others, September 14, 2017. It's part of the docket 18811 Exhibit 10.
And what's in this email?
It goes into quite a bit of detail about significant improvements to Shift4's API and gateway capabilities. J.D. Oder is highlighting specific technical advancements.
Like what?
Like a consolidated enterprise gateway. Explaining it would eliminate the need for older components like the P2PE manager and UTGs.
Okay, those sound like technical payment processing terms.
They are.
Yeah.
Specialized software or hardware for things like encryption and data handling and payments.
Gotcha. What else was new?
He also mentions expanding supported devices, enhancing reporting, talking about a real-time BI dashboard.
BI, business intelligence, tools for tracking performance.
Right, and simplifying the API, the interface that lets different software systems talk to each other. Basically, this email shows Shift4 building out a modern, potentially quite competitive payment processing platform.
And were they just building it for themselves?
Well, importantly, in this same email, J.D. Oder offers to discuss supporting CardConnect's merchant portfolio on this new system. He even attaches a new product brochure.
So Shift4 is actively pitching their new tech to CardConnect, looking for them to potentially use it, migrate onto it.
Seems like it. Which makes the response from Michael James at CardConnect really interesting.
When was that?
The very next day, September 15, 2017. He replies requesting a demo of this new gateway.
So CardConnect, at least at this specific moment, was interested. They wanted to see what Shift4 had built.
Exactly. This whole sequence of communications from 2016 into late 2017, presented as exhibits. It really shows the foundation being laid for what could have been a strong partnership. Integration, mutual benefit. CardConnect even showing interest in Shift4's evolving technology.
But as we know from the case itself, and as the sources reveal, that early optimism, well, it soured pretty significantly.
Yeah, the growing tensions become really apparent in communications from late 2017 and rolling into 2018.
The temperature change.
Dramatically.
Sure.
Let's look at Exhibit A. That's document 20-1. It contains a text exchange between Jared Isaacman and Randy Temming on September 20th, 2017.
Okay.
And the source specifically notes this exhibit was filed in the context of those trade secrets and misappropriation claims we mentioned earlier.
Right. So that gives specific weight to what's in the texts.
Definitely. The messages are highly technical. They're discussing access infrastructure.
What do they say?
Isaacman asks, any luck? Then those backups, I'm told, are the real deal.
Backups.
Then there are updates flying back and forth. Getting firewall changed now, and the confirmation firewall is rock solid now. Great job.
So firewall changes, talk of backups. What else?
Then come requests for specific kinds of technical access. Can we get some port forwards through that firewall? VPN, RDP.
Port forwarding, VPN, RDP, those are all ways to get into computer systems remotely, right? Sometimes bypassing normal security.
Often, yes. Or creating secure tunnels. There are definitely methods for accessing systems,
Yeah.
often requiring privileged setup, highly technical actions.
Okay. Is there more to that exchange?
Yes. And this is the line that really jumps out, especially given the context trade secrets claims. Isaacman asks, also, do we pound their external DNS now?
PMIN, PWN.
Yeah, PWN. It's hacker slang. Essentially means to own or compromise something.
An external DNS, that's like the internet's address book for a domain name.
Exactly. If you control it, you can redirect web traffic for that domain wherever you want.
So this technical discussion, backups, firewalls, remote access methods, controlling DNS, happening around the same time, Shift4 sent that formal breach notice.
Right, late 2017, and before the lawsuit was filed.
The source material presents this exchange as potentially highly relevant evidence for those trade secrets or misappropriation claims.
That seems to be the clear implication from its inclusion as an exhibit in that context.
That language, do we pwn their external DNS now? I mean, wow, that is incredibly aggressive. It's certainly not your standard business chat.
Not at all. And its inclusion as an exhibit strongly suggests it was seen as key evidence related to technical access and control, potentially unauthorized access, which could directly support those trade secret claims.
Yeah, it definitely shifts the picture from just a business dispute to something potentially involving serious technical maneuvering behind the scenes.
For sure. But even while these tensions are clearly simmering underneath, we also see interactions continuing at a higher level. There's an email from Jay Isaacman to John Barrett at First Data, remember, CardConnect's parent company.
Okay, when was this?
January 28, 2018. The subject is Shift4 MasterCard, which suggests, maybe discussions related to card brands or broader partnerships at the corporate level.
And what was the response?
John Barrett replies, offers to stop over in Allentown to discuss it on Wednesday. And he emphasizes, I value our relationship and want to ensure we are staying in good communication.
Interesting. So even with the friction growing between the CardConnect division and Shift4, there were still efforts at the senior levels within First Data Fiserv to keep lines open with Shift4.
Seems that way. Now, operational issues also pop up in these communications, and those constrain any business relationship, right?
Absolutely. What do we see?
There's a text message from J.D. Oder to Randy Oder and Jared Shine. It's Exhibit E, docket 1085, dated April 29, 2018. He's forwarding an email about a new First Data policy.
Another policy change. What was this one about?
It impacted merchants using EMV devices, the standard chip card readers.
Okay.
It meant they'd incur a 10 basis point downgrade fee.
Basis point. That's tiny, right? 0.11%.
Yeah, so 10 basis points is 0.1%. They get hit with that fee on transactions that weren't read via the chip, with some exceptions like mail order, telephone order.
Why the fee?
Well, the forwarded email highlights that while it's presented as a card brand rule, First Data, as the acquirer, can get fined if merchants don't comply. So it seems like they needed a workaround.
And was there one?
Apparently, CardConnect was working on a solution but had no ETA, no estimated time for it, which indicates delays.
And J.D. Oder's reaction?
He asks someone named Stephanie Masiasek to investigate if this is a systemic issue. So this shows how these complex operational and compliance issues, often driven by mandates from the big card brands or processors, they directly impacted the businesses, created friction, and were being tracked internally through these kinds of communications. It's the real-world stuff hitting the merchants caught in the middle.
Makes sense. Okay, what else? The sources mentioned something about contacting Jefferies.
Yes. Exhibit 92 from one of the Lucky Trigger sample PDFs. It's a text from J. David Oder to Jared Isaacman on July 28, 2018.
And it says,
Jared, we are not allowed to contact Jefferies. Per our agreement with FT, call me whenever.
Jefferies, the investment bank.
Exactly. A big one, often involved in M&A, financing deals.
So being prohibited from contacting them, especially linked to FT, which probably means First Data Fiserv,
Right.
that strongly suggests that maybe discussions or potential deals around mergers, acquisitions, financing, strategic partnerships, they were being restricted by the terms of the actual agreement between Shift4 and CardConnect First Data.
Yeah, it hints at strategic maneuvering happening in the background, but bumping up against contractual limits. Very interesting tidbit.
And the emails also show specific examples of problems hitting merchants, right? Making the tension worse.
Oh, definitely. There's an email from J. David Oder dated August 15th, 2018. It's docket 16123, Exhibit 69. And it paints a pretty vivid picture of frustrated customers. He describes pissed off merchants. Why? Because they received bills from CardConnect for July services before they were even converted over to Shift4's platform or even received their new equipment.
Seriously, they were scheduled to convert later.
Yeah, scheduled for August 29th, so billing them for July from CardConnect. That's a clear operational mess-up.
Yeah, billing customers for services they weren't getting from that provider anymore, or before the new one even started. That's bad.
Exactly. J. David Oder clearly believes it's a CardConnect error. Says the merchants need credit memos. Offers to email their names separately.
So this wasn't just some theoretical contract dispute. It had direct negative impacts on shared customers.
And that would inevitably strain the relationship even further. It shows the messy reality of trying to migrate merchant portfolios between providers.
Okay, so things are getting tense operationally. Does it spill over into direct confrontation in the messages?
It sure does. Around the same time, late August 2018, there's an email from Jared Isaacman to Taylor Lavery, also from that Lucky Trigger Sample part1.pdf. And it is remarkably candid and frustrated.
What does Isaacman say?
He writes very pointedly, how long has this been now? 4 or 5 months.
About what?
He continues, you're on a crusade over $25K per month that is less than 1 BPs of CardConnect volume, and you are jeopardizing the entire relationship.
Okay, let's unpack that. 25K a month. Less than 1 basis point, less than 0.01% of CardConnect's volume.
Yeah, Isaacman is clearly framing the disputed amount as tiny relative to CardConnect's overall business.
And accusing Lavery of being on a crusade over it, jeopardizing the whole relationship. That's strong language.
Very. And he asks Lavery to resolve this specific issue before he goes out of office for 2 weeks, implying this seemingly minor financial dispute was a major roadblock and needed immediate attention.
This email feels like powerful evidence, a direct, high-level confrontation over a specific dollar amount and the perceived risk it posed.
Absolutely. And the response from Taylor Lavery. According to the source, it signals that clear shift towards formal legal engagement we talked about.
How so?
It's an email response.
Yeah.
But it requests all further communications go through counsel. And it references a formal letter.
Ah, that's often the point of no return, isn't it? Informal business chats stop, lawyers take over.
Pretty much.
Yeah.
The dispute transitions fully into the legal realm.
And the escalation continues into late 2018, 2019. Are they trying to resolve things or just positioning for the fight?
Looks like a bit of both.
Mm-hmm.
There's a text chain between Jared Isaacman and J.D. Oder II on December 9th, 2018. Again, from Lucky Trigger Sample part1.pdf. It really seems like they're deep in some kind of negotiation. Maybe a buyout, maybe a strategic deal.
What makes you say that? What's in the texts?
Well, they're discussing figures that sound very much like valuations or deal terms. Someone, presumably the other side, is at 11.5.
Okay, 11.5 billion. We don't know, but it's a number.
Right. Then there's talk like, it's a huge step backwards from the 14 plus the 2 bumps and the option of a purchase right.
14 plus the 2 bumps, purchase right. Sounds like deal structure talk.
Exactly. And earlier in the chain, J.D. Oder mentions "roffer at your price."
Paro FR, right of first refusal.
Correct. Giving someone the first shot to buy something before it's offered elsewhere at that price.
So this whole exchange, 11.5, 14 plus bumps, purchase right, ROFR, it strongly suggests they're haggling over a potential transaction, right?
Yeah, maybe acquiring Shift4's rights under the CardConnect agreement, maybe buying a merchant portfolio, maybe something bigger. But clearly there's a significant disagreement on the price or terms compared to what they hoped for or maybe discussed before.
And how does that negotiation end?
Well, J.D. Oder says, let's make the decision together, showing collaboration between them.
Okay.
Then J. Isaacman replies, agreed, don't respond anymore. Followed quickly by, I think we just pass and make out next move.
Wow. That sounds pretty definitive. Like, okay, these terms aren't working, negotiation over, time for plan B.
Exactly, make out next move. It reads like the end of that particular negotiation attempt, deciding to walk away and pursue an alternative strategy.
So by 2019, are things just focused on the impending lawsuit?
Seems like it. The focus shifts to really compiling and formalizing the grievances, which is a clear sign litigation is either imminent or already underway.
What evidence shows that?
There's an email from J. Isaacman to Taylor Laffey and others on August 9th, 2019. It's Exhibit 54. In it, Taylor Laffey is forwarding an attachment and mentions being on a call with their CEO, presumably CardConnect Fizzer's CEO.
Oh, Dad.
Lafee asks if Jay Isaacman has the email that lays out all their grievances.
All their grievances. Okay, that's pretty explicit. CardConnect, or its parent, is actively, formally putting together a comprehensive list of complaints against Shift4.
Yeah, likely prepping for or already part of the legal action. It signifies that shift from informal disputes to very structured legal claims.
And what about internal strategic decisions at Shift4 around this time? Anything in the messages?
There's a text message exchange mentioned in the source, page 48, between individuals identified just as JJT and JPD, dated March 5, 2019.
Okay, what's the gist?
JJT asks, "What is the feedback?" And JPD replies, "He is not going to do a deal with anyone, going to build the risk side himself."
Not gonna do a deal with anyone. Sounds like maybe discussions about partnering or acquiring someone else fell through, maybe related to risk management.
That seems plausible, and the strategic response was decisive. Build it internally. Going to build the risk side himself.
The risk side in payments. That's stuff like merchant underwriting, assessing risk, fraud monitoring, chargeback management, right?
Exactly, those functions. So this text reveals what sound like a key strategic decision point for Shift4, a commitment to internal development, possibly because external options didn't pan out, maybe fueled by the whole CardConnect situation.
Okay, this is fascinating context. Now, let's really zero in on what the sources highlight as some of the most impactful content. Communications that speak directly to the seriousness, the gravity of this legal case.
Right. And there's one specific text message exchange that stands out dramatically. It's from Exhibit 2410, part of Docket Entry 54, parts 11 and 12, dated April 9th, 2019.
Okay, who is it between?
It's the exchange between Taylor Lavery and Jared Isaacman. And the message from Taylor Lavery sent at 4:18 p.m. on that day. It's presented verbatim in the source. And it is, well, quite striking, especially in the context of litigation.
Read it out. What does it say?
It reads, "As for the future, I'd suggest getting ahead and deleting any of the text messages between you and I related to this topic. I obviously don't know if they have the ability to get texts, but better safe than sorry."
Wait, deleting any of the text messages
Yes,
related to this topic, explicitly suggesting deleting communications.
Explicitly. Better safe than sorry.
And Isaac Menman, the response.
Immediately following, also at 4:17 p.m., according to the exhibit details. Okay,
Yeah.
got it. I will do the same.
Wow, okay. That exchange. Suggesting deleting communications about the topic, which is clearly the dispute. That's incredibly significant, legally speaking.
Huge. In any litigation, there's a legal obligation to preserve relevant evidence. Actively suggesting or undertaking the destruction of that evidence, that's called spoliation.
And that has serious consequences.
Oh, absolutely.
Sure.
It can lead to severe penalties for the party involved, monetary sanctions. Maybe the judge tells the jury they should assume that deleted evidence would have been unfavorable. It could be devastating to a case.
So this text message, it directly addresses that point you asked us to focus on, the most impactful content and seriousness of the legal case.
Without a doubt, it introduces this element of potential evidence concealment. And that can drastically affect how a judge or jury perceives a party's conduct and credibility, completely separate from the actual merits of the original claims.
It's just a stark reminder, isn't it? In this age of digital everything, these seemingly casual texts can become absolutely critical pieces of evidence.
And attempts to erase them can be profoundly damaging.
It's also interesting you mentioned the source contrasts this private text with Shift4's later formal legal stance on text messages.
Yes. The source mentions their formal response to request for production number 2, which specifically asked about text message retention policies.
And in that formal legal document, what did they say?
They raised a whole laundry list of objections, saying the request assumes facts not in evidence, that it seeks information protected under applicable privacy laws, that is vague, ambiguous, overly broad, not proportional to the needs of the case, harassing, and unduly burdensome.
Whew. Lots of legal jargon.
And also that it calls for premature disclosure of expert witness opinion, just a wall of formal objections.
So comparing that extensive legal pushback to the simple, informal text message, okay, got it, I will do the same.
Yeah. It highlights that vast difference between private communication and carefully crafted legal maneuvering. And, it potentially draws some pretty sharp scrutiny given the content of that specific exhibit.
Okay, what about other communications that reveal attempts to maybe access sensitive information? Anything else that speaks to the intensity here?
Yes, there's another text chain noted between Jared Isaacman and someone named D. Lau from that Lucky Trigger sample, part 1.pdf again. This one's from November 13th, 2019.
Okay, what's happening here?
In this exchange, Isaacman makes a very specific request to Lau. He asks, Send me a picture of the current monthly revenue and number of transactions from the CardConnect platform.
Whoa, that's sensitive stuff. Internal business data from the competitor's platform, their actual revenue and transaction volume.
Exactly. And Isaacman continues, I want to see what would happen if we applied our pricing model to it.
Okay, so he wants the raw data to run his own analysis. But wait, you said there was more to the message.
Yes. The next part adds a really crucial layer of context. Isaacman instructs, send it to me on Signal since Bruce is on this chain.
Signal, the encrypted messaging app.
That's the one, often chosen specifically for its privacy features, end-to-end encryption.
So, requesting sensitive competitive data and specifically telling the person to send it via Signal and mentioning that someone named Bruce is on a different communication chain.
Right. In the context of this intense legal and competitive battle, what does that suggest to you?
It sounds like an attempt to get proprietary information and maybe ensure the communication happens outside of normal corporate channels, like email or standard messaging apps that might be easily discoverable in litigation.
That's certainly how it could be interpreted. It adds another layer of perceived strategic or potentially improper action.
What did Lau say? Did he send it?
The source notes D. Lau's response was just about not having Signal on his new phone yet. It doesn't say if the info was ever sent another way.
But the request itself and the instruction about Signal, like the delete text message, it gives us a look at communications that seem to go well beyond standard business practice, raising questions about intentions and methods in this highly competitive space.
Definitely. Now, there's also another apparently lengthy email chain described. Yeah. From late 2017, early 2018.
Who is involved in this one?
J.D. Oder II, Taylor Lavery, Jeff Shanahan, and others. It's sourced from Lucky Trigger sample part 2.pdf and sample part 3.pdf.
And what's the focus here?
It provides a really detailed view of that fundamental dispute over the data cap acquisition we discussed earlier. And crucially, the underlying motivations for Shift4's actions, particularly their view on termination rights.
Okay, so what was J.D. Oder arguing in these emails?
He's laying out Shift4's position very emphatically. Based on their legal advice, Shift4 believes the data cap term sheet is definitively not binding.
Right.
And therefore, the LOI, the letter of intent, doesn't violate the exclusivity clause they had with CardConnect First Data.
Okay, same argument as before.
Yes, but he goes further. He argues, countering CardConnect's claims, that Shift4 is not terminating for convenience, but rather to avoid the payment obligation under the agreement.
Avoid the payment. Why?
Because they viewed that payment obligation as being triggered incorrectly, or perhaps based on an agreement they felt justified in exiting for other reasons, like CardConnect's alleged breaches.
So he's saying the reason for termination relates to avoiding a payment they felt wasn't legitimately owed.
Seems to be the gist. He's quoted directly on the source, saying, "It is obvious that the only reason to terminate is to avoid the payment. This is not fair to valued partners."
Strong words again.
Very. He also strongly challenges CardConnect First Data's transparency, and he calls their legal position that the LOI is non-binding and doesn't violate the agreement ridiculous.
Ridiculous. He really wasn't holding back.
No. The source quotes him stating confidently, "I am confident no court would agree with this." It shows this deep, passionate disagreement on the legal interpretation of the agreements and the real motivations behind the termination.
And the sources show Taylor Lavery's response to this?
Yes, his direct counter-response. He states their legal team disagrees, maintains the LOI is non-binding, and therefore the notice of termination stands.
Okay, sticking to their guns.
But Lavery also reiterates valuing the relationship, while arguing the termination is actually in the best interest of both parties to move quickly on data cap, citing the competitive environment as the real driver.
So this email chain, presented as exhibits, it's like a direct transcript of the core legal and business arguments flying back and forth, right as the conflict was really heating up.
Exactly. It shows the opposing legal interpretations of key documents side by side, and it reveals the stated business justifications and the frustrations on both sides. It goes way beyond just the simple claims you'd see in a formal complaint.
And amidst all this conflict, were there other strategic moves happening?
Yes, the sources also show evidence of Shift4 actively acquiring business that was previously associated with CardConnect.
Really? Like what?
There's an email from J.D. Oder II to someone named Andy. It's from Lucky Trigger Sample Part 3.pdf, and it discusses Shift4 purchasing Harbor Touch CardConnect accounts.
Harbor Touch. They were connected to CardConnect.
Yes. J.D. Oder writes, CardConnect's parent, CardConnect LLC, FTC owned, agreed to sell 2,000 Harbor Touch merchant accounts to Shift4. The purchase agreement has already been executed by the parties.
Wow. So CardConnect's parent sold 2,000 accounts to Shift4 even while this dispute was brewing or ongoing.
Apparently so. And Oder frames this acquisition positively internally, saying, it's looking like a terrific and large portfolio that we will be excited to add.
So that email shows Shift4 successfully acquiring a substantial block of merchant accounts that were previously in the CardConnect ecosystem. Another strategic play happening alongside the legal battle.
Precisely.
Okay, we've gone through a lot of the communications. What about the outcome? Do the sources give us any insight into the court findings?
They provide some limited information, yes.
Mm-hmm.
While we clearly don't have the full picture, the text does include summaries of some key outcomes, which definitely speak to the seriousness and the resolution of some of the claims. Again, based only on the text you provided us.
Right. What does it say? Let's start with breach of contract.
Okay, specifically relating to CardConnect's claim that Shift4 breached by soliciting merchants away from them. The source states pretty clearly the court found in favor of Shift4.
In favor of Shift4 on the solicitation claim.
Okay.
What about the claim that Shift4 breached by not onboarding certain merchants?
On that one, the source provides the court's finding as Shift4 was not obligated to onboard merchants that did not meet their criteria. So, another finding, favoring Shift4 on that specific point.
Does it mention other breach claims?
The source just notes mixed results on various other alleged breaches, which suggests some might have gone CardConnect's way, but it highlights these two specific findings in favor of Shift4.
Okay. What about the tortious interference claim, where CardConnect alleged Shift4 improperly interfered with their business relationships?
The summary provided in the source for that claim is unambiguous. The court found in favor of Shift4.
Found in favor of Shift4 on tortious interference as well. Wow.
Yeah. Now, regarding the misappropriation of trade secrets claim,
Uh-huh.
while the source definitely mentions it as a core part of the dispute, the provided summary of court findings does not detail the specific outcome on that particular claim.
Okay, so the outcome on trade secrets isn't specified in this summary.
Correct. But it's crucial to remember, as noted in the source, that evidence, like those technical text messages, discussing backups, firewalls, VPN, RDP, and pooning their external DNS.
Right, from Exhibit A.
That stuff was filed and presumably considered by the court, specifically in relation to the trade secrets allegations, even if the final outcome isn't in this snippet.
Okay, so summing up the court findings as provided in our source material, it indicates that significant parts of CardConnect's case specifically, the claims about soliciting merchants, tortious interference, and Shift4's obligation to onboard all merchants were ultimately not successful. The court found in favor of Shift4 on those points, according to the summary.
That's what the provided text indicates, yes.
So reflecting on this whole deep dive, going through these specific exhibits and messages, from those hopeful beginnings in the early emails,
Yeah.
to the really technical messages about system access and pooning DNS, the operational frustrations over billing and compliance, the blunt negotiations, the conflicting legal interpretations laid bare in those long email chains.
And especially that really striking delete texts message.
Right.
And the request for sensitive data via Signal.
Right. All of it. It offers such a level of granular detail, doesn't it? Such raw insight into this dispute that you just wouldn't get from the formal legal documents alone.
Absolutely. Those formal documents are often stripped of the real-time context, the human emotion. These exhibits put some of that back in.
They really show the human element, the strategic maneuvering, sometimes the operational chaos, the frustrations, and potentially, legally problematic actions happening behind the scenes.
All within what became this high-stakes, multi-million-dollar legal battle. It's a stark reminder that business relationships, even at this massive scale, are played out in these everyday communications.
And the very fact that these specific communications, the emails, the texts, were deemed relevant enough, important enough by the parties or the court
to be pulled into discovery, produced, and actually filed as exhibits in a federal court case.
That just underscores their significance, right? And presenting evidence, building arguments.
Definitely. And accessing these kinds of specific documents, these exhibits, it usually requires navigating official systems like PACER public access to court electronic records.
Which isn't always easy and often charges fees page by page.
Exactly. So this deep dive, curated entirely from your sources, it offers a very specific, targeted look at select pieces of that much larger official court record.
It really provides a powerful, maybe sometimes uncomfortable glimpse into the realities of a major business conflict. playing out and being documented right there in the digital communications of the key people involved.
Yeah. It highlights just how quickly relationships can deteriorate and how these informal messages can suddenly become absolutely central to formal legal proceedings.
So this deep dive has given us a truly granular look at the CardConnect v. Shift4 payments legal battle, drawing exclusively from the source materials you provided.
We've traced that arc, haven't we? From the initial hopes and the contracts through all the operational friction and strategic plays.
To the differing interpretations of fundamental agreements, the arguments over termination motives.
And culminating in some really, frankly, eye-opening communications.
Yeah.
Like that alleged instruction to delete texts or the request for competitive data via Signal.
We've seen how these specific messages, emails, exhibits, they provide such a vivid, almost immediate illustration of the seriousness of the claims and counterclaims.
Yeah, offering insights and exposing potential conduct that those abstract legal descriptions just might miss entirely.
And it really serves as a powerful reminder for all of us, I think, that disputes, even in these complex, multi-million-dollar industries like payment processing, they often boil down to fundamental human disagreements, strategic calculations, tensions played out in everyday communications.
And those communications, captured digitally, they can become absolutely critical evidence under legal scrutiny.
Understanding that helps us appreciate the multifaceted nature of conflict in business and, the potential consequences of what we say or text or email. It's a stark illustration, isn't it? In our digital age, the lines between just informal communication and formal evidence are getting blurrier all the time. Every single keystroke can potentially become part of the official record down the line.
Okay, so here is a final thought for you to consider, based only on the source material we've explored today. Given the court's findings as summarized in our sources, remember, finding in favor of Shift4 on solicitation, tortious interference, and merchant onboarding claims.
Right.
Alongside those massive financial stakes discussed, that $200, $300 million valuation range mentioned by CardConnect's CEO, and the really dramatic nature of some communications, like the delete text message. What does this specific glimpse into this one case reveal about the nature of competition and conflict in this industry? How do the pursuit of these high-stakes financial outcomes and strategic advantage intersect with the way business relationships and disputes are actually managed? Yeah, and how are they sometimes captured in the most informal and potentially damning of messages? Think about that contrast we saw between the formal legal claims and the official responses presented by the parties. Versus the raw, unfiltered, sometimes aggressive or, potentially incriminating communications presented in the exhibits themselves. What does that juxtaposition, drained directly from the source material we looked at, tell us about the reality versus the formal presentation of a major legal battle like this one?
Something substantial to mull over, for sure. Yeah. Thanks for joining us for this deep dive into the raw communications at the heart of a legal dispute.
Until next time.